So for today's discussion, I thought that we can have the discussions in two parts. In the first part, I would like to briefly discuss what is a current scenario in India with respect to at least two of the core issues at the interface of copyright and AI. So one is the issue of copyright ownership, and the other issue is a copyright infringement related claim. So I'll briefly introduce you to where India is in terms of these two major issues. And in the second part of the discussion, I would like to also discuss some of the changes which I would like to see in this area. And I'm sure that Brazil as a jurisdiction is also facing many similar dilemmas. And I'm really looking forward to the discussions, particularly relating to the second part. Now, with respect to the first one, that is the current scenario with respect to copyright authorship and ownership, it may be a good idea to also first see the most relevant statutory provision in this regard, that is, how the Copyright Act in India defines the term author. So there is a specific definition that is given for author under the Indian copyright law, like in many of the other jurisdictions. And for the purpose of our discussion, that subclause 6 is the most relevant one. So subclause 6 says author means in relation to any literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created. The reason why I am specifically showing this particular provision at the outset of the discussion is the fact that now many people, many lawyers particularly, tend to point out to this particular subclause and make the argument that AI generated works can also be protected under the Indian copyright law. And here is one of such examples. So this was a litigation that came up last year. And this was a litigation that was initiated by a student against India's most famous private law school, which is Jindal Global Law School. So if you look at the facts of this case, maybe things are a bit similar or familiar for people from all jurisdictions. So here is one student who submitted a mandatory assignment, which was also subject to evaluation. And the examiners were of the view that the submission contained AI-generated works, and what they did was they failed the student. So the university failed this particular student in the first instance. The student made an appeal before the university, but the university didn't do much about it. And subsequently, what the student did was the student sued this particular law school for failing him over AI generated exam submission. The reason why I am bringing it up here is that if you look at the submissions made by this concerned student, you will notice that at one part of his submission, he is clearly referring to the sub-provision which I had referred to earlier, and then make the argument that, and I quote, if the petitioner did use AI, the copyright of the artistic work would lie with the petitioner, and thus allegation of violation of copyright fails. He further also makes the argument that AI is a tool and a means to an end used for facilitating humans with their research, that the work of the petitioner, although created with the help of AI, is his original work as there is involvement of time, skill, and labor of the petitioner. So of course, I mean, if you look at the petition as a whole, you will notice that the student makes the argument that he hasn't used any AI submission. But in the alternative, he argues that even if there is AI submission, he should be considered as the author of the concerned submission. So that's in a nutshell what the student argued. And as you can clearly see from the submission, the primary statutory provision which he relied on was the definition of author, which I showed earlier. Now, in this particular instance, the case didn't go further because the university also developed cold feet on this matter and they settled the matter out of the court. So the court really didn't adjudicate on this particular question, that is, whether AI generated works can be considered as protectable under the Indian copyright law. But it is also not too surprising for me that someone actually raised this argument in an actual litigation, because if you look at what our copyright office has done in another case, this becomes little bit less surprising. So here is one image which maybe some of you are familiar with, because this particular image was also subject to litigation in the United States. So this particular image, which is titled Surya's, was created by an IP lawyer with the help of an application called Raghav, which is an abbreviation for Robust Artificially Intelligent Graphics and Art Visualizer. So what he did was he used the famous painting of Van Gogh as a base work. And then he had also taken a photograph from the top of his apartment and then asked Raghav to generate the concerned image. And when the system generated the image, what he did was he went to the Copyright Office, sought registration. In the initial application, he had only mentioned Raghav as the author of the concerned work, and not too surprisingly, the Copyright Office rejected the application primarily on the ground that the copyright can only be given to human beings. But then something more interesting happened. He filed another application wherein he put himself as a co-author in this particular work, and to many people's surprise, including me, what our copyright office did was they granted registration, wherein, as you can see from the screen, both Ankit Sani, the concerned lawyer, and Raghav, the system, have been mentioned as co-authors. Of course, this also became a big news. So there were articles like this which says that yes, India is recognizing AI as co-author of copyrighted work. But again, for people like me, this was a big surprise because we hadn't made any changes in our statute to make AI a co-author under the Indian copyright law. So the Copyright Office also then slightly changed their position and said that now we are going to revoke this particular registration. But the interesting bit here is that the Copyright Office doesn't have the power to revoke and granted registration. What they will have to generally do is they have to approach the High Court under a particular section and then get it revoked. But what I can see even during my recent search on the Indian Copyright Office database is a fact that this particular registration hasn't been revoked yet, which means as it stands today, we at least have one work wherein A has been mentioned as a co-author. So that's where India stands today. In this regard, it might also be a good idea for you to look at how the Indian Copyright Statute defines a work of joint authorship. So it says it means a work produced by the collaboration of two or more authors in which the contribution of one author is not distinct from the contribution of other author or authors. There have also been some case laws which try to set the standard with respect to joint authorship. And here is one of such case laws, and I will just quote the relevant part. It says, if there is intellectual contribution by two or more persons pursuant to a preconcerted joint design, to the composition of a literary work, then those persons have to be regarded as joint authors. As you will notice very specifically from the wordings used in this particular decision, the focus has been on persons, and clearly the indication was, yes, this is limited to natural persons only. But the problem is that when the Indian Copyright Office analyzed the application, it really didn't go into these nuances. What they did was they just granted that registration by presuming that, yes, AI can also become a joint author under the Indian copyright law. Even though, again, I want to re-emphasize, most of the case laws, if you read them or if you look at the statutory provisions that are currently existing, it is very clear that AI cannot be an author under the Indian copyright law. Just to give you one example, the term of protection that is given for copyrighted works is very much tied to the life of the author, right? So in those instances, how do we actually calculate the term? The Copyright Office really didn't think about it when it granted the registration. And as I indicated earlier, till date, that particular application, to the best of my knowledge, is remaining on the register. In this regard, I should also mention one additional thing. So some of the lawyers and scholars in India were also arguing that maybe we should also think about conferring juristic personality on AI. So as most of us know, at times we also confer juristic personality, for example, on companies, because we want to make them liable for the bad things which they do, right? So in those instances, yes, we confer juristic personality. And if you look at the case laws from India, one of the things which you would notice is, in the past, the courts have recognized juristic personality for many things, including rivers, trees, etc. So that makes some people to argue that maybe in view of the developments in AI, we should also confer juristic personality on AI. But to me, again, I mean, this is slightly problematic, because if you look at the case laws in this particular area, and on the screen, I have put one of the very recent or relatively recent Supreme Court decision, wherein you will notice that the courts have clarified that the conferral of legal personality by courts is an innovation arising out of necessity and convenience. And most importantly, the courts have clarified that the careful examination of the purpose sought to be achieved by conferring legal personality is very much necessary. So if you really want to confer legal personality to A, one of the things which we should do is we should also justify why that is required. For that, we might have to go back to theories of copyright law and then ask ourselves, is there a valid justification for granting juristic personality to A? But as it stands now, as you might have already learned from the discussions with Professor Allan and so on, there aren't many strong reasons why we should be granting copyright for works that are generated by AI, and particularly works that are autonomously generated by AI. I think that's something which we need to recognize. So that's where we stand with respect to the conferment of authorship and copyright ownership over works generated by AI. At this point, it might also be a good idea to contrast it with what is happening in the US. So I earlier mentioned about the Surya's example. What you need to know, if you already don't know, is that in the US also this was subject to litigation. And in the US Copyright Office, the US Copyright Review Board, as well as the court, have clarified that that application cannot be granted copyright protection because human authorship is a vital element under the US copyright law. So this is in sharp contrast to what we are seeing in India now. And this principle was also re-emphasized in a more recent case, that is Stephen Taylor versus Shira. And as at least some of you know, this decision came from the US Court of Appeals only in March 2025. And this was a work-in question. Again, here you will notice that yes, the US Court of Appeals is re-emphasizing that human authorship requirement is existing under the copyright law. And most importantly, the second point which they had clarified, I think is very important here. That is, Dr. Taylor has not explained how a ban on machines being authors would result in less original work, because machines, including the creativity machine, do not respond to economic incentives. So this very much ties back to what I mentioned earlier. If you really want to confer juristic personalities so as to grant copyright protection, again, we need to have strong legal and policy reasons. And here is a US court observation which categorically points out that yes, machines do not respond to economic incentives. So then under what ground are we actually justifying the grant, or under what ground are we actually supporting the grant of copyright protection for AI generated works is an important question that we need to keep in mind. The other important reason why you should all read that decision is how the court was also analyzing the work for hire doctrine argument there. So there also you will notice that the US Court of Appeals categorically pointed out that the human authorship requirement necessitates that all original works of authorship be created in the first instance by a human being, including those who make work for hire. So you cannot just transpose work for hire doctrine and argue that yes, you as the owner of the machine should be having the copyright over the work. You have to first show that the work created is created by a human being. So that's again a very important point to be kept in mind. So that's where we are on the authorship, copyright ownership dimension. And as you can clearly see, and as I mentioned earlier, the position which India has taken is in stark contrast to what the United States has taken and what many of the other jurisdictions has actually taken in this particular regard. Let's look at the second dimension, that is copyright infringement. So here, before I go to one of the relevant case laws, maybe I should also clarify what is the exceptions framework under the Indian copyright law. So, as most of you know, if you look at the jurisdictions across the globe, you will see some countries following the open-ended exceptions framework. The best example is a US fair use system. The other extreme is a enumerated exceptions, primarily seeing in continental Europe. And if I understand correctly, in Brazil also, you're more or less following that approach, right? I mean, Alan, you can correct me if I'm wrong there. And then, of course, there is a set of countries that are following a hybrid exception model. And India is following that hybrid exception model, wherein you will notice that we have a not fully open, but a bit open fair dealing exception. But we also have a fairly long list of specific or enumerated exceptions. But one of the important things which I should clarify at the outset is that India doesn't have a specific text and data mining exception. So what we have is a fair dealing exception, which can cover some of the situations like research, private study, etc. And then we have set of enumerated exceptions, but we don't have a specific TDM exception. Now, in November last year, we saw the first GenAI-related copyright case in India. So this particular case was initiated by a news agency. So you can imagine it as something like a national version of Reuters. And what they did was they sued OpenAI, saying that OpenAI, without the permission of ANA, has used their materials for training purposes. And they also argued that in many of the results which ChatGPT is generating, you can actually see verbatim reproductions of ANA contents. So there are a couple of issues here. So these are the 4 issues identified by the court. I know they have used a fairly complex language there. So for ease of understanding for everyone here, so the first question is relating to the training dimension. So the question is essentially whether the use of plaintiff's data for training purposes amounts to infringement. The second question is with respect to the reproduction of the plaintiff's material as part of the responses constitute infringement. Then the third question is whether the defendants, that is OpenAI's use of the copyrighted materials, constitutes fair use under the relevant exceptions provisions under the Copyright Act. And the fourth question is also an interesting one, that is whether the courts in India have jurisdiction to entertain this particular suit, because the servers of OpenAI are not located within India, they are located in the United States. I was one of the 2 amici appointed, amici that is friend of the court appointed by the Delhi High Court in this particular matter. So I may not be able to make many comments relating to this particular litigation. But what you will generally notice from the framing of the questions is that this is very much resembling the litigation or set of litigations that are happening in the United States. The most important one being the New York Times litigation. So here also the underlying material is news related material, and again, as most of you would agree, the extent of copyright protection over news is limited. So that's one of the important things which we have to keep in mind when we deal with a litigation like this. And that's also the reason why I would compare it mostly with the New York Times litigation in the United States. If you look at the status of this case, you will notice that the court is still continuing the arguments. So what the court did was they started with the arguments of the amici first. So I was the first one to make the submissions before the court. Then the other amici presented his arguments, and then the parties, that is the plaintiff as well as the defendant's lawyers, have presented the argument. One of the interesting things that has happened is many other organizations have also now filed applications as interveners in this case. For example, the Publishers Association has now filed an application for intervention. Similarly, the music industry has come and filed an application for intervention. So we really have to see where this will go. Of course, as you can imagine, the nature of subject matter would change with respect to these interveners. So the court is also taking a slightly cautious approach with respect to many of these intervention applications. So again, if you look at the status, what I could say is that we might have to wait for some more time to see where things go, because so far only the plaintiff and defendant side is completed more or less. So we still have to see how the court is going to deal with the interveners applications. So I expect that maybe sometime towards the end of this year, we might see the outcome in this particular case. Again, if I compare it with the situation in the United States, as most of you know, there are like many litigations happening in the United States in this area, maybe close to, I think, 30 litigations. But what is most interesting, or what should be of most interest for all of you, should be a recent report, a pre-publication report that was released. So it was released only last month by the Copyright Register. And as at least some of you might have read from the newspapers, the Copyright Register was also fired the very next day. So some people also say that she was foreseeing the firing, and then she released it on the eve of her position in the Copyright Office. But what is quite interesting in that particular report is that the report as a whole appears to be taking a position which is more in favor of the copyright holders. Of course, it emphasizes at multiple points that the situation will change depending on the specific facts and the specific purposes for which the copyrighted materials have been used. But if you look at the general tone of the report, to me, it is very much leaning in favor of the copyright holder. So if in any case you haven't discussed this report already as part of your course, I would strongly encourage you to discuss this particular report because it's a fairly controversial one. And to be frank, I also don't agree with many parts of the analyses that have been made there. And as at least you would also know, maybe by reading more about it, many of the US scholars also tend to disagree with some of the strong positions taken in the concerned report. Now, let's move to the second part of my presentation, that is what could be the ideal approach. So we have already seen what India has done so far with respect to AI authorship ownership. We already saw where we are in terms of the copyright infringement litigation in this area. Now let's see what could be the ideal approach in my perspective. So for that, it might also be a good idea to first see what other things have happened in this area, particularly the position which our legislators might have taken. So one of the interesting reports is a report that was released in 2021. So there was a parliamentary standing committee which reviewed the IP regime in India, and this is a 161st report of this particular committee. And there, one of the interesting things which you will notice is that the committee says a separate category of rights for AI and AI-related inventions and solutions should be created for their protection as IPRs. It further recommends that the department should make efforts in reviewing the existing legislations of the Patents Act 1970 and Copyright Act 1957 to incorporate the emerging technologies of AI and AI-related inventions in their ambit. In other words, yes, they are suggesting that there should at least be a review of the provisions. And generally, if you look at that report, they are also in favor of creating a separate category of rights for AI and AI-related inventions. Interestingly, last year, someone also raised a question in the parliament as to whether the current IPR regime is well equipped to protect AI generated works. And the interesting thing here is that the minister who is in charge of this particular area gave a reply saying that all is fine, nothing needs to be done. But what might be of substantial interest for discussion in a group like this is the following observations, and I will just read out that part. It says the exclusive economic rights of a copyright owner, such as the right of reproduction, translation, adaptation, etc., granted by the Copyright Act 1957, obligates a user of generative AI to obtain permission to use their works for commercial purposes if such use is not covered under the fair dealing exceptions provided under Section 52 of the Copyright Act. It's quite interesting, right? Because one, it says, yes, these companies will have to obtain permission to use works for commercial purposes, but when should they seek permission is the interesting question. It says if such use is not covered under the fair dealing exception, which means it is not answering the question, but it is actually extending the ambiguity that is existing in this particular area. So it is in this context that I thought maybe I should share some of the perspectives of mine on how to go forward. So my general recommendation with respect to this particular area is a three-prong approach. One, I am generally someone who advocates for a broader exceptions framework. So in the context of machine learning also, I am of the view that we need to have a broad exception framework. But what I also specifically argue, particularly in the paper which I shared, is that maybe we should complement that broad exceptions framework also with a strict approach with respect to copyright ownership for AI generated works. Because if we take a lenient approach with respect to exceptions and also take a lenient approach with respect to AI generated works, the situation might very much disturb the balance which we are currently seeing within the copyright system. So what I am really advocating is liberalize the exceptions framework, but also make the copyright ownership dimensions stricter. More specifically, instead of rushing into the granting of copyright protection for AI generated works, what we should do is what many other jurisdictions are doing, that is, do a wait and watch approach with respect to that question. I also argue that we should evolve disclosure norms, and maybe we should also have effective opt-out mechanisms for people who doesn't want their works to be used for training purposes. Let's see them quickly one by one. So with respect to the exceptions framework, my specific suggestion is to change our fair dealing exception into a fair use exception. And I also argue that maybe we should retain the enumerated exception. So there is a reason for that. So as most of you might be aware, while fair use has many advantages, one of the challenges is the uncertainty in outcome in a litigation. So it's very hard to predict ex ante what activity would be exempted from infringement liability. And that may not be good for a country like Brazil or India. We might want to have more predictability for all stakeholders. So for that reason, it is also very important to have a list of enumerated exceptions where we are clear that yes, this is an activity that will be clearly outside infringement liability. And there, yes, we should not just retain the current exceptions, but I also think that we should have strong exceptions like text and data mining exception. So in a nutshell, what we might need is, yes, one fair use exception plus a list of enumerated exceptions. With respect to the conversion from fair dealing to fair use, as you might know, many countries have already done. South Africa is still debating whether they should do that. And I'm also suggesting something similar only. So currently, the provision is limiting the fair dealing exception to private or personal use, criticism or review, and reporting of current events and current affairs. What I'm suggesting is that maybe we should just use those three as examples. So instead of for the purposes of, what I'm suggesting is we should say purposes such as, and then give these three examples. That would ensure that, yes, the copyright system will be able to address any of the emerging challenges. So that's the first major suggestion. The second, as I mentioned earlier, is that we should take a wait and watch approach instead of rushing into the granting of copyright ownership for AI generated works. And we have to have a very calibrated approach here, because not all kinds of AI generated works deserve copyright protection. For example, if a work is completely autonomously generated by AI, I think there is hardly any theoretical justification. But on the other hand, if AI is just used as a tool in creation, maybe there are more justifications. So we need to have a differentiated approach there, and that takes time. So instead of rushing to grant copyright protection, we need to have a wait and watch approach. The third, as I mentioned, is evolving disclosure norms and also having effective opt-out mechanisms. So with respect to the disclosure norms, the minimal which I think we can expect is at least seeing a summary of the copyrighted data used for training. Again, this suggestion is not in vacuum. So we have already seen that suggestion emerging from EUA Act. But again, I want to reemphasize, this is kind of a minimal, I would say, expectation. As technology improves, I'm sure that there would be better ways to communicate which are the materials that have been used for training. As it stands now, maybe that's not possible, but yes, that may not be that far away. With respect to the opt-out mechanism, again, I mean, this is also a subject of litigation, this is one of the issues in the current Gen A litigation in India. So, as some of you know, OpenAI already allows an opt-out mechanism. So if, say, for example, any of you doesn't want your website to be used for training purposes by OpenAI, all what you need to do is use robots.txt protocol, and then yes, they won't crawl through your website. Is that effective? Maybe only time will tell. But what is very clear is that in the current scenario, instead of an opt-in system for training, an opt-out system might be better, because we don't have a mandatory registration system under copyright law. And as long as we don't have a mandatory system for copyright registration, maybe it is opt-out, which is more preferable. So if, say, for example, Professor Allan doesn't want his articles to be used for training purposes, yes, Professor Allan can exercise that option, and then yes, these firms won't be using his works for training purposes. And to me, maybe that is a way forward. But whether the current opt-out mechanisms are effective enough, again, that's something which we don't know clearly now. Only through, I would say, more litigations, we would have a more clear idea in this particular regard. So to summarize, what I would say is that copyright system as it stands now is on a very delicate balance, and as you can imagine, the large language models in particular have challenged that balance. So it is very important that by we I mean jurisdictions such as Brazil, India, etc., take a very cautious approach with regard to the developments in this area. On one side, yes, we are clearly seeing anxieties from the side of the copyright holders. As you might have also seen, many writers, many singers, etc., are very much worried about their works being used without any compensation in return. But on the other side, we are also seeing enormous possibilities of machine learning. And as we can clearly see, as we are moving into a co-creativity, I would say, age with machines. In that scenario, yes, we have to have a very delicate balance within the copyright system. And I strongly believe that only through conversations like this, particularly conversations within the global south, we will be able to achieve that balance. So with that, I will stop my introductory remarks here. I very much look forward to hearing and learning from all of you. Thank you.